I am also trying on my side to send messages.
Will do, Chairperson. Chairperson, there's a hand from Ms. Clark, Honorable Clark.
Honorable Clerk. Yes, Honorable Clerk. Honorable Clerk.
I don't know.
Can Honorable Clerk, can you
hear
please
me?
unmute? Yes.
Chairperson, I just wish to inform you that I am at the doctor. He is running very late. So I'll stay on the meeting for the decisions until he's ready to see me.
No, thank you very much. I will try to be very quick. Thanks for that.
Thank you very much, Chairperson.
Good day, Chairperson. Chairperson, we have 2 new members with, so that makes it 6 members, and we can proceed with the quorum. Thank you, Chairperson.
Thank you very much. You can share the agenda, please.
Thank you, Chairperson. Agenda online.
Thanks, members. Can we get a mover and seconder for the agenda as presented?
I move for the adoption, Chair.
Thank you very much. Yeah.
I second, Chair.
Thank you very much. The agenda has been adopted. Any apologies?
Chairperson, no apologies on our side, just that Ms. Colby, she will join late as she's just taking a flight at the moment and will join immediately thereafter. Thank you.
Okay, thank you very much. And then we're hoping other members will still join as we conclude our work. Thank you very much. Can we now have the presentation, in particular focusing on the new issues that were raised in the meeting and plus the submission that was made by the DA?
Thank you. Good morning. Good morning, Honorable Chair. Good morning, Honorable Members. I'm going to share my screen. I'm sure everybody can see my screen. Let me just enlarge it. Honorable Members, Chairperson, following the meeting of the 29th, which was last week, Monday, the Constitutional Legal Services Office has incorporated the agreed changes to the bill. We've also discussed various policy issues arising from the meeting on Monday. We've discussed this with our team leader of the drafting unit, Advocate Charmaine van der Merwe, and therefore we have incorporated several drafting refinements to produce a tighter, a cleaner, and a more readily interpretable version. So, Chairperson, as a way of introduction, I'm going to simply focus on the amendments, and these can be found in blue on the version in front of members. As you can see, members, due to the amendments, we have needed to amend the long title. Oh, sorry for that. The long title of our bill. So we've added now to provide for the establishment of the Residence Committee at each parliamentary village and to provide for its role and functions and to provide for the role of SAPs at the parliamentary villages. So this is to incorporate what we've amended and the new additions to the bill. The next amendments that we have, Chairperson, is the amendments to the arrangement of sections, because we've added new sections, and these can be found in blue. There's also a new chapter, Chapter 5, we've added a residence committee chapter, and that's because we've now created more governance roles for the residence committees. You can see we've added a new section with regard to the role of SAPs. Moving on, Chairperson, to our definitions. We have added a new definition, residence committee, as the decision of the committee created a more distinct governing process for the residence committee. We have now included a definition for the residence committee, as they do play a more distinct role, as you can see. We then move on to the First Amendment. Yeah. And that can be found at 12.2. Chairperson, honorable members, this is a new section and addresses the submission from the DA under item C, which was agreed to in the committee, regarding the loophole that created in 18.6, where the accounting officer could potentially be the chair or the deputy chair of the board. So now, as you can see, honorable members, we've included an amendment, which is subsection 2, that only voting members of the board can be the chair or the deputy chair. And these can be found, the voting members can be found in 18.4 of the Act, which is 9 board members from the Residence Committee, the housing chairperson, the house chairperson in the NCOP responsible for parliamentary villages, and the 3 chairpersons from the various residential committees. The next amendment, honorable members, can be found in section 13 under paragraph C. And this is to address Honorable Kobe's suggestion that the role of SAPS be more clearly pointed out. Although SAPS is a member of the board, we have expressed that SAPS, we have expressly now provided for SAPS's role more explicitly in the Act. Also, as SAPS is a member of the board, C now includes a safety aspect and as a distinct role and function of the board. So it's now to state that the board will facilitate and take necessary steps to ensure safety and security of each of the parliamentary villages and its residents, and can also make recommendations to the minister regarding policing. If we move on to G, honorable members, this also addresses the proposal that expressed, which is item B of the DA proposal, that we propose that they propose express guidance to the sanctions and that they should be provided in the Act. Honourable members, you recall that we had said in the meeting that the rules could provide for these sanctions, but then, however, on discussing the matter with our team leader, we included this provision. So as you can see now, it states that we can, the board determine sanctions such as paying a fine or recommending the termination of a lease agreement. So those are the parameters in which the sanctions can be determined, providing a sort of guidance to the board as proposed. J, honourable members, is just for clarity. We introduced the word written report. We're going to move on now to 16. So 16.3, when we consulted our team leader, we created a clearer audium alterum partem provision, and therefore the executive authority, before removing, can gather other information and facts before determining whether they can remove a member from the board. So you'll see we added and may gather any other information in order to determine whether the facts constitute a ground contemplated in subsection 2. If we move on to 18, honourable members, we've also included the term under subsection 3, voting. And this is to just provide a clearer drafting. We propose that now you can clearly note that only voting members can declare votes in writing. We're moving now on to 20, honourable members. So section 21 has been amended. It is now separated into two paragraphs, A and B, to address item E of the DA submission, in that there was no clear governance provisions for the Residence Committee. So B now provides that the board must report to the executive authority on the dissolution of the Residence Committee. Prior, we did not have a disillusionment clause regarding the Residence Committee, and now because we've included a dissolution clause, we now say that the board must report on any of that, and the period stipulated in section 31(4), which I will get into when we get there, honourable members. If you look at 21, honourable members, so this does not follow any particular proposal per se, but it is a drafting amendment. It's also to provide that the vacancy process must be followed when a member is removed. So we've included that. So before it just simply said when it was vacant, that the vacancy process should be followed, but also that also we need to factor in removal. So we've included that for tighter and more succinct drafting and clearer. So chapter 5 is a new chapter, honourable members. We have now, as you were aware from last week's meeting, there was a proposal that we perhaps, and it was agreed to by the committee, that we include substantial governance procedures for the Residence Committee, and we do not leave that up to the Residence Committee to decide. As the board had specific governance processes, the committee felt that there was an excessive discretion left for the Residence Committee, as opposed to the board having clear guidelines with regarding the governance. So therefore, the request was to include governance processes in the bill for the Residence Committee. And as there were substantial changes to the section dealing with the Residence Committee, we created an entirely new chapter dealing with this. You can see now that under 23(1), we've also included a clearer understanding that only voting members, although there are nominee officio members of the Residence Committee, only voting members at the AGM will be called on to elect the voting. Only residents of the various residents will elect voting members of the Residence Committee. So if we look at section 24(2), also here, it's also clear now that voting members must elect a chairperson and deputy chairperson amongst themselves. So only voting members can be the chair and deputy chair. We go on to 25. We added this to provide that the reports would contain advice from the unit heads relating to reports on safety and security, that this should also be included in the functions of the Residence Committee. That's under A. And G now provides that the Residence Committee can refer a breach of the rules to the board. If we look at the duration, honourable members, instead of the membership of the Residence Committee being linked to the board, we have now linked it to the term, because the Residence Committee may be functional and the board may be dissolved. So we had then discussed it with our team leader, and she suggested that we perhaps link it to the term of Parliament, because why should a functional Residence Committee's term be hedged on a board's term? And therefore, we've now linked it to Parliament's term. If we move on, honourable members, you'll see 2 is just also for clearer drafting. By the board was added to make it clear that members of a Residence Committee may only be removed as a member as contemplated in section 1 by the board. If we look at subsection 3, this is a drafting amendment, but it's to create a better Audi alterum partem provision similar to what I just explained in the board. If we move on now, honourable members, we're looking at 4 new sections, sections 28, 29, 30, and 31. And these all address item E of the DA submission. We have now taken into account the decision by this committee to provide for rules and regulations governing the Residence Committee. You can now see that there are rules relating to meetings, quorum and voting, vacancies, and dissolution. I'm going to focus a little bit on dissolution. and I want to highlight this to the committee, that this section regarding dissolution, so my colleague Ms. Kassan, who drafted this section, considered body corporate principles as this reflects a similar scenario as we foresee the residence committee acting as a sort of body corporate. So subsection 1 reflects instances where dissolution is possible. As you can see, honourable members, these are similar to that of a body corporate: loss of confidence, continuous failure, and irreconcilable conflicts. Then if we look at subsection 2, the board will then intervene by vote to dissolve. And then subsection 3 then focuses on the notification of the decision by the board. Subsection 4 then goes on to 4 reports that we believe are important to sort of curtail any problems with the residence committee that can be solved by the executive committee. So this is on advice from our team leader that perhaps each step of the dissolution process be reported to the EA to curtail any issues with the board, with the residence committee. We're going to now move on to chapter 6. We've now created a section dealing with the role of SAPs. There's now a clear role for SAPs. This is to address Honourable Kobe's concern, and this is taken from the input that SAPs provided to this committee. So section 33 is the regulations, and honourable members, you can see under paragraph C that the amendment provides that the regulations can now also be prescribed regulations, a prescribed regulation process of determining breaches. And this is now under C, so that can be done via regulations. So honourable members, the savings provision, you will recall that we have amended our savings provision and transitional arrangements substantially because this addresses in the previous meeting item A of the DA submission. We had further also realized that initially the draft did not clearly spell out the role of the old board versus the new board, and therefore we amended section to clearly state that process. You can see now, honourable members, that it now reads that until the first meeting of the newly constituted board established by this Act, the Parliamentary Villages Management Board continues to function, and any written or verbal agreements between the Department and Parliament, the Parliamentary Villages Management Board and Parliament, or the Parliamentary Villages Management Board and the Department that was binding on the villages immediately before the commencement of the Act continues to be binding on that board. So this clearly now spells out the role of the Parliamentary Villages Management Board and agreements thereto vis-a-vis the new board. If we look at subsection 4, any written or verbal agreements between the Department and Parliament relating to the parliamentary villages, including maintenance, operation, allocation of accommodation entered into before the commencement of this Act, continues to be binding and in force until terminated by Parliament. This is also to create a clearer understanding of the role of the board and the role of the Department and Parliament before and after the commencement of the Act. So section 35 is a substantial amendment, honourable members, and we've now first created a new in-time definition for the 7th Parliament. And the reason being, members, is that when we considered the initial draft, we considered the issue that the Act provides for the board to be constituted 60 days after the allocation of accommodation. However, if the Act is operational in this 7th Parliament, what then, honourable members? Allocation of residence has already occurred. And when does the executive authority constitute the board? Similarly, all allocations done in the 7th. Similarly, also, what about the housing allocation forum? If the Act commences in the 7th Parliament, do we establish the housing allocation forum? Similarly, do we establish a new residential committee, or do we stick with the old residential committees? These were all questions that we only realized after looking at the submissions by the committee and also re-looking at the bill. And therefore, we have provided the following amendments. I'm going to go down there. So first, we've said now at 4A that all allocations done in the 7th Parliament are deemed to be done in the manner that we have set out in section 5. So we needed to validate all allocations currently done. And honourable members, just to be clear, this is if this act is if this act comes into operation in this 7th Parliament. So all allocations that were done already, the allocations that were done already will be deemed to be allocations done in terms of this act and in terms of Section 5 that we've now created a procedure for allocation. So it's a deeming provision. That's what we call it. The second section paragraph is paragraph B. So this refers to the Housing Allocation Forum. And we have two options for members, so we'll need a decision with this regard. So the first option is we say the Housing Allocation Forum only is established in this 7th Parliament if further allocations are needed. Or we could say we establish the Housing Allocation Forum 30 days of commencement of the Act, but with the proviso that, provided that the Housing Allocations Forum established in terms of the 7th Parliament may only decide on new or further allocations to be made during the 7th Parliament, or to consider disputes regarding allocations. So the two options that we're asking members to decide on is, we only establish the Housing Allocation Forum if further allocations are needed, or do we establish the Housing Allocation Forum 30 days from commencement of this Act with a proviso? We then also say in paragraph C that we state that allocations must be considered through the provision that we've provided for, using the latest audit report undertaken. And we also state that you must use the members' facility handbook and also consider the number of persons requesting accommodation. Paragraph 6, section 6, subsection 6 then talks about or speaks to the, sorry, I'm going to go back. Subsection 5 speaks to lease agreements. We realized that we needed to validate all lease agreements by DPW until the accounting officer enters into new lease agreements. So we provided a time frame for that. We provided that they will remain valid until that time. If we look at subsection 6, we then also provided a time frame for the accounting officer to give to submit the KIAMP and the UAMP, and also submit that to Treasury. We then also factored in the commencement of the Residence Committee in terms of section 23. And this we now have done in a subsection 7, where we say in the event that section 23, which talks to the election of the Residence Committee, commences during the term of the 7th Parliament, we state that the accounting officer must, within 30 days of the commencement of section 1023, call a general meeting at the Parliament. So this is that to ensure that if this act commences during this term of the 7th Parliament, that the AO will simply call the meeting.
Chairperson.
Sorry?
Sorry, Doctor. I had to join a meeting.
Can I continue? I'm nearing the end. So this, just to be clear here with subsection 7, the accounting officer simply calls the meeting. Residents still vote. But we had to add this in just to ensure that should this act commence in the 7th Parliament, that 30 days from commencement, we call a general meeting and then residents can vote on new residence committees. Finally, we also have included a subsection 8, which says that in the event that section 14, which is board appointments, occurs during the 7th Parliament, the Executive Authority has 60 days of commencement, will then appoint new members of the Parliamentary Religious Management Board. Lastly, honourable members, section 37 has also been amended to state that the Executive Authority can determine the operation of the, and proclaim it in a gazette, the operation of this act. And we have precedent for this. So it is above board, it is legal. so to speak. And then we've also factored in different dates for commencement of different sections of this Act. And those are the amendments, honourable members. Thank you so much.
Thank you very much. Members, I hope you have followed. Can I just ask the team on procedural issues, on incorporating and approving those, do we go section by section? Or we allow members to raise their views, ask questions for clarity, and then from there we move for a decision. Maybe let's ask for questions of clarity in each and every section, and the team, if you can just make notes, and then we'll follow. Assist me with the hands as well. I want to see whose hands is up. Can I take hands, members? Can I take hands for clarity, comment, suggestions? Members, are you there? I see two members. Member Litchfield Chabalala, and followed by member Ramolubeng.
Thank you, Chair. I was going to suggest that we saw this last week, and some of these amendments, we actually asked for them ourselves. So I'm not sure if we want to do section by section. I think that people should just raise their hands directly to areas that they seek clarity in or input in. Thank you, Chair.
Thanks, Chair. One, I would seek clarity on something. Two, I think I would have preferred us, Chair, to go section by section so that we have a better understanding of what is it that we are agreeing upon. Unlike going to sections that we members would want to raise matters on, because it will not necessarily conflict, but it might not go well. But if we know we're dealing with the section 6, if there's clarity needed on it and then there's agreements to it, we agree, we move to another one, like we did when we were sitting in a physical meeting in Good Hope. It was more quite progressive when we followed through each section, and we were able to know and trace what is it that we're agreeing upon. So that's one thing I wanted to suggest on that. But two, Chair, I wanted to just get clarity. I'm not sure whether the presenter was going too fast, or maybe I might have missed some of the things. We're on recess or expected to be a constituency work, and I was in a meeting before this one. I've heard, I'm not sure which section is it, but there was where there's a mention of linking the residents committee to the term of parliament, obviously being 5 years, which I agree with it. Do we still have the board being linked to the term of parliament? I just want to get that clarity. Is the board linked to the term of parliament? Because here I see the amendment talks to the residents committee. It's just a refresher, Chair, so that I'm in line with what I'm about to agree on. Thanks, Chair.
Can we provide the responses?
Chairperson, can I respond to Honourable Ramolobeng's question?
Yes, please proceed.
Honourable Ramolobeng, if you look at section 15, the duration of membership, the term of office of the board is linked to the parliamentary term.
Okay, are there any vehemently opposition to the amendments? based on the input as well as the meeting suggestion of Monday. Because I think the matters for me are straightforward, but we just need to make sure that we properly approve. Members of the committee.
There's a hand by Honorable Kubani, Chairperson.
Honorable Mbubane.
Yeah, Chairperson, I wanted to ask for clarity as well. There was some pronouncement about the contract's termination or whatever. I wanted to know from the public works, aren't those matters more of operational nature? Because remember, those folding around or finalization of those contracts will be a handover to the new administration that will take over whatever work that is done by public works. Are those elements of whatever public works, the termination of contracts, transfer, more operational matters than really legislative matters? Like they are a once-off wrapping off of what public work was doing. I don't know whether I stand to be corrected. Should those things not be included in legislature because they are not permanent? They're just wrapping off of what is handing over to the new regime, if I can get clarity on that.
Chairperson.
Yeah, thank you. I think we had agreed, and you'll correct me, that there needs to be some transitional provision. I don't know, the team can maybe technically tell us. Let's deal with that issue and then come back.
That is correct, Chairperson. For that reason, it is in the transitional provisions, because transitional provisions may provide for a transition from one regime into another.
And the question is, how does it impact on the legislation? Because the legislation is permanent. How have you normally managed that so that the members are clear?
Transitional provisions are only for a period of the transition. So it's still part of the legislation, but it's for the transition. So that's why you call it a transitional provision. Once it's over, it's over. Once that time is, it's drafted in such a way to factor in that transition.
Okay. Thank you very much. Are there any issues, colleagues?
There's another hand, Chairperson, Ms. Ramaloben.
Ms. Honorable Ramaloben?
Thanks, Chair. I wanted to check, are we doing it section by section so that we can then input on it, or we're just throwing it in so that I know whether the further inputs or ideas or whatever that I would have, should I wait when we deal with the portions of the sections, or should I just shoot in now? Chair, it's a because of I would have raised that we go each section, and Honorable Litchfield would have raised that we just shoot as and when there is a need arise for us to get clarity, so that one is structured on how to proceed. Chair, thanks.
Yes. My understanding is that, colleagues, what we will do, we will focus. Remember, we've dealt with many of these sections. There's that section in blue, which was being read today. I don't mind if members can take us through section by section, then we then agree, approve, and then we finish. But not on the old things that we've already. I don't want us to open the old discussion because we've resolved on it. Legal, can you advise so that we can proceed?
Thank you, Chairperson. I'll just share my screen. Chairperson, I just would like to also remind members that the purpose of the meeting is to create a version or adopt a version. This is not the final adoption of the draft. This is we're adopting a version for advertisement. So once it is advertised, the version will go out to the public, to all the stakeholders for comments and input. We then will return to this committee to adopt a version, following any further amendments that will arise from substantial input from the public and from the stakeholders. So the first amendment that we did on the version that was presented last week, Monday, was to the long title. Should I pause, Chairperson?
Are there any comments on the long title? In particular, the addition in blue, because it covers the areas that the meeting agreed to sponsor. So if there are no comments, I'll take it that we agree. Or
Yes, Chair, we can proceed.
Okay, thank you very much. The next session.
We added a new definition.
Any issue with the new definition? Okay, we can proceed.
So the clarity amendment.
Just contextualize what was this clarity about so that members can follow. Can you please clarify?
Sorry, Chairperson, I was muted.
Oh.
This was to address the loophole that the chairperson and deputy chairperson could potentially be non-voting members. So now we have made it clear.
Okay, are there any issues with that, members? Thank you, we can move.
The second amendments were dealing with Honourable Kobe's SAPS issue. And this is why we added C to make it a function of the board.
Okay. Are there any issue with C? Okay, we can proceed.
G was also to address the proposal regarding sanctions and guidance for that.
Thank you. Are there any issues with that? Thank you, can proceed. I think there's a one you, after G, you didn't jump anything.
No, it's just this was just an amendment to make it more clear. I'm not going to focus on like clarity, things like written report, Chairperson, or do you want me to? I can do that.
No, I just wanted to make sure that I didn't miss anything. We can
Okay,
proceed.
sure. No, I can go through every single change. It's just like this would just to make it more clear. Instead of just report, we want a written report.
Okay.
Chair, can I interrupt you a bit? Ne? Sorry, I didn't raise hand.
You can proceed,
Hello, Chair?
Honorable Member. Yes, Honorable
Yeah.
Ngoni, you can proceed.
Chair, what I want to ask from Talana, this amendment of board-related activities, is it in line with the corporate governance like Institute of Directors board functionality? Because now when we creep in, what are the reasons for creeping in to say the deputy chair and the chair of the board are non-voting members? Because on some, remember, it's only the chair who's a non-voting member. He only decides when there's a tie. But because they are part of board members as well, not that they are outsiders. So what informs bringing that in to say the deputy chair and the chair are non-voting members? Because normally on board's term, corporate governance and Institute of Directors, those are members of the board who always have rights to vote only if there's a tie. The board chairperson then becomes a voter.
Okay, can you clarify that?
The chairperson and the deputy chairperson are voting members of the board.
Okay, clarified.
Okay, thank you. Thank you very much. We can proceed.
The next amendment is 16.3, and this was just to create a clearer audium alterum partem provision, and therefore the EA before removing must gather information.
Okay, are there issues? If none, we can move.
(18.3) is just to make it clear that voting members.
Okay, that's quite clear. We can move.
(21) is now split into 20A and B, And this was amended to show that, to address the submission that there was no clear governance provisions for the Residence Committee. And now we have done a reporting line that the board must submit reports to the EA on disillusionment.
Okay. Thank you. Is it clear? Is this clear, members? You can move.
Sure. 21 deals with vacancies. This is just also another clarity drafting amendment where we factored in that besides vacating an office, a member could also be removed, and therefore the vacancy process must be followed.
Okay. Any comments, members? If none, we can move.
So 23, Chairperson, 23 is a whole new chapter, chapter 5. This deals with all the governance issues with the Residence Committee. So now there is, it's clear that there are now governance procedures relating to the Residence Committee, similar to that of the board. So
Thank
that
you.
you can see, yeah.
Thank you. Any comment? If none, we can move.
We've also added a function relating to reports by the Residence Committee on maintenance, safety and security and any personnel appointed. And also we refer to G, where the Residence Committee can refer a breach of the rules to the board. These are the two amendments under the functions of the Residence Committee.
Thank you. Are there any comments, members? If no comment, we can move.
26 relates to the term of office of the Residence Committee. It is now linked to the term of Parliament.
Thank you. You can proceed.
27 is the resignation and removal. So instead of so that we did an Audi alterum partem provision similar to that of the board. So it's to create an opportunity for the board to consider oral and written representations and also gather information before determining
Thank you.
the removal of a member. And like I said, 28, 29, and 30 are all new provisions, and 31 dealing with governance aspects of the Residence Committee. Before we left it entirely up to the Residence Committee to determine their own governance precepts. Now we have it set out in the legislation. And the disillusionment, now there's a disillusionment clause dealing with how the Residence Committee can be dissolved if the residents are dissatisfied, have lost confidence, there's continuous failure, or there's irreconcilable conflicts of the Residence Committee.
Any comments, members? Because we insisted on ensuring that we can prescribe upfront and we don't let it loose. Now the provisions have been made. Are there any issues, members? Members are fine. We can
good,
proceed.
Chair.
Okay, thank you.
Okay, Chair, the next section is 32. It's the role of SAPS. We've taken this from the SAPS input to this committee and we've now explicitly put it in the legislation.
Okay, any comments? Members, if you recall, you had raised some initial issues. I'm not sure whether they are covered here, including things like SARS not just being, security guards, but to provide other services, police services for the residents. Simple things like. So I'm not sure whether there's a need for us to include that, or it can be assumed. Maybe you can guide us on SAPS providing additional police services for the villages.
I just want to point out also, Chairperson, that it's not a closed list. It says services include. So there could be other things added onto the list, but this is just sort of to provide guidance. And I think that's what this committee wanted in the previous committee. We had also thought that it could be left out, but I mean, seeing that this committee agreed to having a more distinct role for SAPS, There is a board member that is a SAPS official on the board, but we included this for the benefit of clarity.
Okay, but will it be harmful to add just to say SAPS to perform other policing services within the precincts where they are? even if we don't prescribe them as items.
Okay, can I respond? If you read the 32(1), it says SAPS is responsible for providing protection, policing, and security services at Parliament.
That's
And
fine.
and then it goes on. Okay, sure.
Okay, thank you. Members, we are agreeing?
My hand is up, Chair.
Yes, my honorable member.
Thank you. I was agreeing with you when you were raising issues under this section. If I'm reading the list that I see on the screen, I'm not sure how different it is from what SAPS is already doing now, actually. And I know that when we raised this issue, we wanted them to operate as a proper SAPS outlet, not like if something happens to me now, as a resident of Acacia Park, they can't open that case. In the end, I still have to go to Goodwood while they are there as SAPS. So we were raising fundamental issues like that, and I don't see them captured here. So I don't know how we want to phrase that. And I mean, I know this document is at strategic level. We can't go and prescribe every service, but I still feel we should capture a line that says they need to be
Yeah, I think it's that one.
Chair, mute, Chair.
Apologies, I'm just trying to check out the hotel in East London. Sorry for that.
No, that's fine, Chair. So I think, Chair, we need to capture a line that says we need them transformed to a fully fledged SAPS station, because these functions, I don't see them any different from what they're already doing. Thank you, sir.
Any comment from the technical team?
Chairperson, so this section was taken from the current and also what SAPS has proposed to this committee. As you recall, SAPS had presented to this committee on what they are capable of doing at the parliamentary villages. I cannot say whether it is according, like if it will be in line with SAPS legislation to open up a fully fledged SAPS station at the precincts or at various villages. It's not in my mandate to do that, and it's also we have not had input from SAPS to see whether they are able to do that. We draft legislation for effectiveness, Chairperson, and it wasn't in our mandate to inquire whether SAPS should be a fully fledged unit in the villages. The committee should also, I think a way forward would be that when we advertise the bill, the committee can request that SAPS consider the bill, and that if there is a possibility that they can open fully fledged SAPS units within the villages, they can provide input on that and be invited to the committee to propose ways to do that, and whether it is in their capacity, that they have capacity to do that.
Yeah, I don't think that we are trying to make unreasonable proposals to SAPS, but it was more about additional, just basic services. We don't want a police station because we have no control of budgets and things like those, right? Just additional basic services where we can report, they refer, something like that. In the current setup, we don't want to change the current setup, but just to enhance basic services, including things like if you want to certify a document, those things that doesn't require additional resources except the stamp. So it's not a fully fledged SAPS services at the precinct. I think that will be unreasonable. Please explore that. We can pass this, and then so when the bill is advertised, if there are issues, then we can consult with SAPS and come back. And if there's any other amendments we want to make, we'll come back. But otherwise, we're fine.
Chairperson, there's hands of 2 more members. Honorable
Yes.
McCarthy. Honorable McCarthy is next,
And
and then
mine also.
Honorable
It's a new hand.
Chabalala as well.
You
Thank
can
you.
come in, colleagues.
Chair, just to check on 32F, investigation of reported crimes committed in the Parliamentary villages, whether can't we also add that and provide a full written report so that there's some kind of tracking and accountability of cases that have been dealt with for maybe the next board that would come after the sitting one, because I think for example, in the last meeting we had, we just received a verbal report from the police that we were hearing of reports and incidents that happened in the different villages. I think it was Acacia to be specific. So I just wanted to check, can we also add that part of saying that they must, after investigations of these crimes committed, that there should be a full written report that is provided to the board. Thank you.
Thank you very much. The next hand.
Thank you,
next-
Chair. I thought Honorable Clark will come before me because her hand was up first, but she's quiet. Yeah, Chair, I agree with you. Fully fledged, we did not mean that it should operate like in any other subs. I think the matter related to, they are supposed to be able to open a case of a crime that has happened within the residence and be able to follow that up and not deal with me, come to my house, say someone attacks me in my house or it's a domestic violence. They will come, they'll talk to me. I give them a statement. We must still go to Goodwood police station. I mean, why don't they have the powers to be able to open a subs case and have a case number? I mean, it does not need them to be given any extra resources from what they are now. Truly, they just thank you.
Honorable Clark is next, Chairperson.
Honorable Clark.
Thank you, Chairperson. I'm so sorry. My doctor called me in halfway through the meeting.
You are now muted, Honorable Clark.
Sorry about that, Chairperson.
Honorable
Yeah,
Clark.
it's quiet. I don't know if it's
Honorable
quiet by
Clark,
me.
could you kindly unmute? Chairperson, the content advisor, Ms.
Hello?
Oh,
Can you
there we
hear
go.
me?
Please go
Yes, we
ahead.
can hear you
Clark.
now.
Honorable Clark, you've muted yourself again. Sorry, I don't know why this is muting me every time I move to where I've made notes for my questions. Can you hear me?
Yes, proceed, please.
Yeah, they are muted again. We can't hear anything.
And now, can you hear me?
We can
Yes,
hear you.
now we can hear you.
Okay, I'm terribly sorry. I don't know why it keeps on doing that. Okay, so the one clarity seeking question I want, and I'm sorry to take you back, there's only two questions I wanted to ask. and that is the questions of clarity relating to the saving sections. In multiple sections, there is now a desire to retain any written or verbal agreement between DPWI and Parliament related to the parliamentary villages until the commencement of the Act. It may be advisable to get a sense of what those verbal agreements are and how they are so important to keep in transition, as that seems rather shaky than should be clarified to the committee. And I don't know if that was discussed while I was seeing the doctor, so that was the one question. The other question around the entry into force of different provisions. The new Section 37 gives significant discretion to the executive authority as it relates to the operational commencement of different provisions. It also goes on to stipulate different debates may be fixed. Even if in principle this gives flexibility, in a complex ongoing situation, it is also important that mechanisms does leave a partial release, a partial realized act that creates further administrative headaches. And also in Section 35(4) of the transitional agreements, two options are to be considered by the committee. Option 1 basically suggests that the housing allocation forum for the 7th Parliament is only established on a case-by-case basis, and option 2 is that the housing allocation forum is formalised and established within 30 days after the commencement of the Act, but only done for the new or further allocations. I personally don't have strong views on this matter. And what did the committee decide on those two options? Because that's when I went into the doctor's rooms, because at this stage, the whips of each party deals with the allocations of housing stock that's been allocated to each political
Is this
party.
the last section?
Yes, was it the last section that you decided on? There were two options, Chairperson. Which one was decided on, the first or the second?
Section.
We have not decided, Chair. We're still going through the sections.
Okay.
By we're
Okay.
still
Okay.
Yes, we
Okay.
haven't,
Thank you.
we
I was
haven't
just
decided.
concerned about that because
That's okay.
I wasn't listening. Thank you so much, Chair. Thank you.
Thanks, Honorable Clerk. Can you please, legal, can you proceed?
Chair, can I just ask Honorable Clerk for some clarity regarding, so her question, she had 3 questions. Obviously, we're still going to deal with the housing allocation forum. We haven't gotten to that section yet. Regarding the savings provision, Annika Clark, our researcher for this task, she's going to do an audit on all current agreements, verbal and written. So I think that will provide some clarity and provide a sense of what these agreements are. Regarding her question with the short title on the commencement, Section 37, I just require some clarity from Honorable Clerk. Is Honorable Clerk asking why we want some flexibility with regard to different fixed dates for the commencement? Is that the question?
Yes, I just want some clarity on that. Thank you very much.
Okay, so Honorable Clerk, the reason why we put that section, that subsection regarding different dates may be fixed for proclamation is that there could be an instance in this Parliament where we only have capacity or we only have to use the political will or ready for certain provisions. In case in point, you could have an incident where we're not ready yet to be custodians, but we're ready to do allocations. So we could then say that certain sections, like the allocation section, we'll start to do, or the dissolution of the board we'll start to do, but until we have the capacity or the funding, or we haven't even got the budget yet to be custodians, we'll then only, those sections will then come into operation.
Thank you very much. I'm happy with that.
Thank you.
No, that's fine. Proceed.
No, Chair, excuse me. I've not been answered. Honorable Clark came in and then she was entertained. I have not been answered on what I asked
Oh,
and suggested.
Apologies. Telani, do you still remember the question from the member?
Yes, Chairperson, I think this pertained to the written report to the board. I'm correct, Honorable Chabalala, right? Litchfield Chabalala, you had said something about whether we can perhaps even do a written report on instances where SAPS provide an investigation. Chairperson, I just need some indication from the board if you want me to include that as a part of the services in the list under section 32, but also remind members that there is a...
Excuse me, no, that's not what I said. I said, sir, when we say fully fledged, obviously we don't mean like any other. It's not like a substation in Kukuletu or Elsis River or even Kudud or wherever. What the issue was they should be given powers to be able to open a case. Because if anything happened to me in any of the villages, even if they come and they engage me, I must still go to the nearest substation to report that case. It doesn't make sense. They are there. Why are they not linked to the central data? Why can't I open a case with them on a crime that happened within the village and have a case number? Why should that function be seconded to the nearest substation, but they are there? That's what the issue is.
Just 1 second before you come in. Honorable member, we've agreed that with regard to the subs, because anything that will include additional resources, either personnel or financial, will require us to be tested with subs. The reason why we want to move ahead is to ensure that we can consult on this bill. And we did direct the team that in the meantime, we need to interact with SAPS to see what sort of other provision can be made to make sure that at least it's not just about opening and closing the gate, but other basic services are provided for. I think that was the line that we were taking. But let me allow Terani to come in.
Chair, if I may.
Terani, you can please continue to provide an answer on the question of Honorable Litchfield.
Chair, can I come in here, please?
Yes, please.
Yes, Chair. The more direct way to deal with Honorable Chabalala's input is to include a section 35H, which includes the registration of criminal complaints. So we are saying that is the service SAPS would be included in as the services SAPS will provide, but it still leaves it up to SAPS in terms of how they are going to do that. So for example, I've had a breaking at my house. SAPS came to my house, they took my statement, they issued me with a case number in my house. So that could be one of the ways in which SAPS can provide the service of registering criminal complaints. It might be that they want to put a mini sub police station there, but that will be up to them. So to me, adding a 35GH, which includes the registration of criminal complaints, would directly address Honorable Chabalala's inputs, Chair.
Is that sufficient, Honorable Chabalala, for the purposes of what you're stating?
That's what I have been saying, Chair.
Okay. Thank you. I think we're covered. Then we can move.
Okay.
So this section, yes.
Chairperson, can I just get clarity? So I'm going to include 32H, register criminal complaints, and then also 32J, which is provide written reports there too. There was a comment from yourself. I thought it was Honorable Chabalala, but I think it was yourself that
It was
requested.
me. It was Mrs. Honorable
It was.
Makasi.
Yes, sorry. Yes, Honorable Makasi, that we provide written reports on investigations. So maybe I should amend F to include and a written report there too. So can I get confirmation from the committee whether I can make those additions to this version and then advertise?
Chair, if I may.
Yes.
I think on your submission or comment that you made in relation to the additional services that are to be provided by subs, it covers a variety of all services by subs, because I think Honorable Chabalala is referring to incidents that are happening around the precinct of the parks, or maybe at the doorstep, where police would say, you must go to an ordinary police station because the incident happened outside the precinct of the park. For inside, they do record those cases and take them. For instance, you would have somebody being robbed, whether at gunpoint or knife point. They would not take that case. They would direct you to go to a police station that is of the community. So it means therefore that while we are then guarded by the police, if we're in the park and we are honorable members, let us be allowed to then have additional services that are provided in a normal police station without having to drive far, because you know that other members are dependent on the transport provided by Parliament, which is buses. They are not able to even go to this police station. So I think the wording additional services by subs, for me, is suffice, and it would cover any other that may arise along the way. Thank you, Chair.
Over to the team. I think we found each other. We can proceed.
Chairperson, can I just get clarity on what we need to amend at 32? Can you please confirm that I need to include an H, and then also amend F to include written reports?
That's an understanding.
Yes, it is.
Thank you, Chairperson.
It is.
Okay. Let's proceed.
Chair, we now go on to section 33, 33C. It's an amendment that now we can also do regulations, prescribe regulations regarding breaches.
If there are no comments, we can proceed.
Thank you, Chairperson. 34 is the savings provision regarding the written and verbal agreements. These two amendments pertain thereto.
If there are no issues, we can proceed.
35 is the substantial amendment regarding the transitional arrangements. We've now included an in-time definition for 7th Parliament. And because it's transitional arrangement, just to relay the fear of Honourable Ngubani, that is why 7th Parliament is an in-time definition and isn't included in the main list of definitions, because it only pertains to this transitional arrangement, which is a transitional provision. I need a decision from the committee regarding, yes? Should I pause? If I can move on, Chairperson, the transitional arrangements that are being changed are to factor in the occurrence of this act coming into place in the 7th Parliament. And one of the options that we need to receive input from this committee is whether we should have the Housing Allocation Forum established now, once the act is in commencement, for any further allocations needing, or should we only establish the Housing Allocation Forum 30 days of commencement and only when further allocations are needed or there are any disputes? So I just need a decision between these two options.
Okay, members, your preference, please. Option 1 or option 2, so that we can proceed. Yes, Honorable Ramulwen.
Chair, thank you so much. I would propose that we go with option 2, that 30 days after the commencement of the Act, a housing allocation forum be established to deal with additional matters that may occur. But if there is nothing that is occurring, the status quo remains, Chair. But as and when there are matters, new matters that requires to be attended to, or if there are also disputes that emanate from the previous allocations that arise from the 7 administration. So I would go with option 2, Chair. Thank you.
Thank you. Any other contra review from option 2?
Agreed, Chair. Option 2.
Supported, Chair.
Great, great. Let's move to the next section. You are muted. We can't hear you now on this new section. Please, if you can just start from scratch.
Sorry, Chairperson. So the rest of the section deals with what happens in the 7th Parliament if this act is in commencement. It deals with the lease agreements. It deals with the camps. It deals with the Residence Committee and also deals with the board.
Any comments, members? So we are fine on this section. I think we can move.
And that's it, Chairperson. The last thing was just the amendments to the Executive Authority proclaiming and then the different dates of operation.
Okay, my hand is up on the previous part.
Okay, Honorable Ramlobe.
If Telena can go down.
Sure. Is this fine, Honorable?
Yes, it's fine. I think I need on the Residence Committee and the board. If I'm correct, there was where we indicated that in an absence of the board being established, the current one status remains as it is up until a new one is formulated. Chair. So here it speaks of 60 days after commencement of this act, a new parliamentary villages board needs to be done. And then 30 days after this, if I'm correct, Helena, a new residence committee should be done as well. I'm not sure if
Yes.
I am doing this correctly.
Yes, so what these two provisions say is that, okay, so we have residence committees and we have a board. But if this act comes into operation during the 7th Parliament, within 30 days of the commencement of this act, you will then constitute a new residence committee and you will constitute a new board. That is because previously we did not have that provision because we drafted the legislation on the presumption that it would probably only be commenced in the next Parliament. And as you know, these committees are established on allocation of new residents into housing. So because that is a factor that is not an eventuality that is not going to happen in the 7th Parliament unless it's new allocations, we had to provide for what happens in an instance where the act is operational in the 7th Parliament. We have residents in housing, but we need a new board and we need new residence committees in those sections, if those sections are commenced with.
Thanks, Chair. Chair, if I can do a follow-up. The current residence committees, I know of the board, it was based on DPW interpretation. They would have said annually, which would have argued against that. But with the residence committee current form, it doesn't speak to annual, it speaks to a term, which is 5 years. And I'm not sure the act that governs a residence committee, it allocates, it puts them where in their term of office of operation. So in this instance, Chair, my proposal on this one, if there isn't any current form of an act that indicates the term of residence committee. So the assumption would be the residence committees that were elected, that were elected, because there was an election that took place. I not want to say appointed, elected, I think it's sometime last year, by all residence committees. The assumption is that they will conclude their term 2029 when 2029 when we gear up to the 8th administration or 8th Parliament, if I'm correct, Helena, because of days, we were not told that the residence committees must elect new leadership or committees annually, as unlike the board. And if that's the instance, my suggestion would be that if the act kicks in this administration we're in, with the residence committees having been elected already, with an assumption that they are going to conclude their term when Parliament comes to an end, which would be 2029, the status quo remains. If the act comes in place, the current committees that are in existence in villages to proceed with their work, the act must be able to recognize that. Then the new residence committees be done after 2029, when Parliament has when the seventh term has concluded its term, Chair. So I'm not sure if you understand me, Telana, because there's no term of office of residencies. The assumptions that we were told when committees were being elected was that it's the whole 5 years. So when you are now saying when the act comes into a place, if let's say it comes into place next year in 2027, new residence committees must be established. For me, I would say the status quo remains up until after 2029, Chair. So whether the act comes in now or later, it must not tamper with that election of residencies, because it is
Point well made. Point well made, Honorable Ramolube. I think what we must do, Tilano can advise us, we need a transitional clause which will incorporate the current status into the future so that we don't destabilize. But you can just take us through on the suggestion and then we're able to conclude.
Okay. Honorable Chair, I think Honorable Kobe's hand is up.
It's Honorable Kobe, not
Kobe,
Kobe.
okay, Honorable Kobe.
Thank you very much.
Sorry.
Good day, colleagues. No worries, Talana. And thanks, Honorable Ramolube. Chair, I just wanted to maybe seek clarity on what is the current status of the committees, the village committees, because in the previous act it did say annually. And I think as a committee, we decided that the status quo remains until the new law comes into effect. I'm not too sure if I'm taking the committee back, but I think the previous, stemming from the previous law, it did say that it is an annual, the committees change annually. And now we have suspended that until we finalize the finalization of this legislation. And once that comes into effect, then I think that's when maybe we can see how a new board then constitutes, because we then don't even have the DPWI and its officials. We then have a new executive authority who then must apologies about that, the new executive authority must then constitute the new board. So I think I need then clarity over that. Thanks, Chair.
Thank you. Let's provide a response and then conclude, colleagues. We need to start moving.
Thank you so much, and sorry for anglicizing your name, Honorable Kobe. Honorable Ramolobeng, I think you raise a very good point. The act that as we drafted, we did not factor in that this committee would like the old residence committee to remain in existence. If it is the desire of this committee to create a savings provision to provide for the existing residence committees to remain enacted or remain in process or existence. We can provide for that in the savings provision. We can provide to something similar to what we said regarding the old board. And we can state that the residence committee would remain, the current residence committee would remain in existence until the next parliament, if that is the desire of this committee, or until the act, because currently as it reads is that we could also just do it, we could also draft it in a way to say that the current residence committee remains in existence until this act is operational. And then we say that when the act is operational, that within 30 days of commencement of this act, we then constitute new residence committees. But what I'm getting from what Honorable Ramolobeng is saying is that it is a desire to perhaps have these residence committees in existence until only the next parliament when new allocations are done. But I just need instructions from this committee. Is that what is desired? Regarding your question, Honorable Kobe, the board is still in existence until the new board is established. And what we have now done is in the transitional arrangements is that if this act becomes in existence now during this term, that we will then have the executive authority within 60 days appointing a new board. And I hope that provides some clarity. But like I said, I just need guidance from the suggestion by Honorable Ramolobeng.
Chair, if I may come in and be able to explain properly.
Yes, please proceed.
Thanks, Chair. I think Honorable Kobe would have further made clarity or emphasized when she seek clarity on the board, that the board, yes, it's annually, but on residence committees, it has never been indicated that it's annually. It's linked to the term. That's why when elections happened last year in electing new committees in all committees, there has never been an anticipation that annually there will be new committees that needs to be elected into villages. And I'm saying this in instance, the DPW, when it was commencing in wanting new, to establish the new board, since they indicated that the one that was established or appointed last year, it has come to an end. They requested the current existing committees of residencies to make submissions of 2 names, which exclude the chairs, because the chairs automatically would sit in the board. The 3 name submissions to form part of the board. There was never an indication to say new leadership of committees needs to commence. So it's in that basis that I say, since residence committees are 5 years linked of their term of office, let that not change due to the act coming into commencing before this term of the 7th Parliament comes to an end. Would the board fully agree with it, that the current status of the board must stay up until the new act comes into play? When it comes to a play, then the new board needs to be established. And that would have been made with the indication of residence committees making submissions of 3 names to form part of the board, which includes the chairs. But the residence committee one, it should stay up until the term of Parliament, which is the current form that it is sitting in. So we must not say 30 days after commencement of the act, if it's within the 7th administration, new residence committees needs to come into play. The board in agreement, but the residence committee should stay as it is up until this term concludes. Thanks, Chair.
Can you, the technical team, can you interact with the input so that we can conclude? I think the point has been made by all members. If you can just formulate it.
Yes, I will, but I just want a question of clarity, Chairperson. Is what Honorable Ramolobeng suggesting that we have, we keep the old residence committee until the new Parliament? Does that mean then you want the old residence committee to operate in the functions that we've now provided for the new residence committee? So the new residence committee have new functions, they've got a new procedure and governance and that sort of thing. So and composition of the new residence committee is totally different to what the current residence committee, do you want us to keep the old residence committees operational, but you would want them to operate as we provided for in this act, but what do we do then with the composition? Because I think the composition, and I might be mistaken, is a bit different to what we have now suggested.
I think, Telana, we then need to align we agree that once the residents committee, or I agree that once the residents, the act comes into play, the current residents committees, which its term concludes when the term of parliament ends, should then effect the new governance system that the act provides that it should follow. Then we must find a way of aligning what the current act talks to in terms of the composition of residence committees. It's a committee of certain numbers. I know Acacia Park, it's a committee of 10 people. I'm not sure in Pelican and Liberia, since they're small, how many composition is that? But we then need to align those with the current form of the act. But we do agree that the status quo be kept, but alignment of what the act provides should then be considered by the current residence committees. Thank you.
I second that Mr. Ramolobeng is saying for continuity purposes, so that this new act be implemented by people who are familiar with the changes and the ongoing on, rather than creating new things or from scratch everywhere.
Chairperson, may I respond? Hi,
Yes,
Chair.
you can proceed, please.
Yeah,
Can
sorry.
proceed.
And I don't want to delay this committee by any means, but I'm just struggling on how to draft that. So it's going to be a little difficult to try and translate that to legislation. So this committee wants us to still keep a previous residence committee operational, but they want the new residence, that same old residence committee, they want the functions, the governance prescripts to apply to that old residence committee. But some of that functions and some of that governance prescripts include new constituted members. So I'm struggling to find out how to draft that, but let me, I don't know where that leaves this process, because this process was meant to provide us with a draft that would go out on advert. And we as drafters would need to go back now and think about how to redraft those sections, which will take a considerable amount of time, at least a week, because I need to wrap my head around how to constitute a current board, so to speak, and in terms of governance prescripts, how to align that with a new constituted formation of that board. Residence committee.
Chair, may I please come in?
Yes, you can proceed.
Thank you, Chair. Just to ask Telana, what are the material differences between the old board with reference specifically to the residents committee and the one that you're drafting now with the legislation? Because if we go back to drafting again, we're going to delay this.
Sure, Honorable Kobe, and through you, Chair, the old act didn't even provide for how the residence committee should be formulated and what that constituted. So we don't even know what that looks like at the moment. But I can tell you that the current composition of what we wanted 3 members who reside in the village.
So I just need to know what are the
support staff, sessional, and then you also have non-voting members, which is a SAPS official, a designated department official, service providers, and an official from Parliament. So I suppose, we could then like my worry is that because there was no governance prescripts of the residence committee, there could be in certain parks 7 members and different compositions in each member. I mean, Honorable Ramolobeng said that she knows of that certain parks have a lot smaller residence committees and some have a lot bigger. But my worry is that I could have 7 residences on a committee where I just need 3 residential members and 1 support in the new composition. So I need to factor in, I will have to draft something around reconstituting compositions, factor in removal of certain members that don't like. I'm going to have to like. I'm spitballing, but I'm going to
Can
have
I
to sit
just-
and think.
Can if I may, Chair, through you, Tilana, according to my understanding, the new constitution of the board constitutes of the various chairpersons of the various residences already, which we currently have. So that wouldn't materially change because it's just a matter of transposing the sitting chairpersons. We don't need to elect new ones as per the agreement and the desire of this committee. So already in terms of governance and the composition, those members will move from the old board into this one nonetheless. So I just need to know what other extra members do then the chairpersons need to move around or elect to belong to the new board, so that you don't go back and rewrite the legislation or draft again. So we can transpose what currently exists as the status quo, and to say then who then gets removed, who then it's just a matter of numbers, so that we can align those numbers with the current or the new board. But the chairpersons, by de facto, remain within the new composition. So I don't think that there's a lot of maneuvering or movement that needs to be done. I hope I'm not speaking outside the confines of the law here. But according to my understanding, if we are going to keep it relatively the same, we're going to have, by and large, the same members in the new board as we do at the old board, because the chairpersons of the residents wouldn't have changed, because we're not going to change as per the desire of this committee. We're not going to change residents committees. I'm not sure if you get my point.
Honorable Corbians, without making this conversational through you, chairperson, we're not now at this point. The issue is not the board. I think Honorable Ramolobeng's question pertained to the residence committee. I think we are all on the same page regarding the board, that the board is constituted annually, and that should, according to the old act, it in terms of the DPW's interpretation, it has a term of an annual, but this we're talking about is the residence committee, and the fact that Honorable Ramolobeng suggested that the residence committee remain operational, the current residence committee. I think we're all comfortable with the old board, the new board being reconstituted at the commencement of this act, that there be a new board. I think the issue now is the residence committee. Am I correct, Honorable Ramolobeng?
Through you, Chair, you are correct, Helena. I think we are in agreement with the board composition, but where Honorable Kobe must understand that if there would be changes or we should elect a new residence committee when the act comes into effect, it also automatically changes the chairs, because it means the new election of the residence committee would mean including the current chairs of villages get affected, because they would then need to be elected again. So the election process that we went through last year, Honorable Kobe, will go to them again. And the chairs that comes out of the elections after the act comes into effect would be the ones that automatically sits in the board, waiting for 2 additional or 3 additional, which is 2 residence committee and 1 additional sessional worker to accompany them to sit in the board. So The reason I am suggesting that the status quo on residence committee be kept is entirely what Honorable Ngubane indicated, that the current people who are serving in those committees, and including the board, understand this act because most of them are sitting in this ad hoc committee and will be able to make sure that there is a smoother transition in making sure that the act is adhered to in terms of operations, organizational structure, and that the 8th Parliament, when it resumes, if the act comes into effect whilst we're in this 7th Parliament, at least systems are put in place and it's a much smoother transition for them to be able to do it in the 8th Parliament. But coming to that, Telena, what I want to understand, the Residence Committee, what was the composition that the Act suggests that it has? I understand of the board, but what is the current composition of the Residence Committees when they get elected? Like I indicated, Acacia is 10 people, and I'm not sure Pelican and Liberia, how many are they? They can be 6 or 7. So the current act says how many people should be elected out of residence committees or the composition of that structure. Perhaps we should start it there and see whether there are serious changes that needs to come into effect so that we're able to find a way forward out of this. Thanks, Chair.
Thank you. Telana, do you want to come in the last bite and then we can conclude on this matter? I think we've belabored it
Yes,
now.
Chairperson. That in essence is the problem, Honorable Ramolobeng. The old act, I mean, the act as it is, I'm calling it the old act, but the current act says nothing on residence committees. I presume, and Annika can come in here as the policy developer, that the residence committees were probably constituted in terms of rules or in the various residents, or they might have had different constitutions even pertaining to, but there's nothing in the act on how residence committees are currently appointed. So we could have a situation where different parks have different rules pertaining to the constitution of their residence committees. Hence the reason, or the constitution and the composition and the election of committees and how they govern their meetings, etc. Hence the reason why we had now included that in this new act, how we elect residence committees, what those residence committees look like. So the act that we are proposing says that a residence committee will consist of voting members and non-voting members. Of the voting members, we have 3 members who reside in that particular parliamentary village. We have 1 support staff member who resides in that particular parliamentary village. And then we have 1 sessional official who resides in that parliamentary village. And then we have non-voting members. We have 4 non-voting members. We have an official appointed by Parliament to manage the administration and day-to-day operations of the parliamentary village. We then have a service provider, if there is a service provider, appointed by the accounting officer to manage and represent that service provider. And then we have a representative of the department designated by the minister. And then we have a representative of SAPS as appointed by the Western Cape Provincial Commissioner. So now I have a situation where that is what we are proposing the residence committees look like. Currently, we have no regulations governing what the composition of the residence committees look like. I have a suggestion that we keep the previous residence committees, and I can do that. I can keep the old residence committees, but you have now wanted a situation where the suggestion of this committee is to keep that residence committee until the next parliament, and then use the current governing prescripts that are suggested for the new residence committee. Now, my problem is that I can do that. I can do a savings provision and say the old residence committee will be operational and functional until the new parliament, and will function on the certain sections. I can say section 28, 26, 27, 28, 29, 30, all apply to the old residence committee, but the problem is the composition. Now, I don't know how to draft a clause to say that where the composition does not look like the suggested composition, that we amended. I'll have to think about that. I'll have to take at least a week to think about that.
Chair.
Yes, I see there is a hand.
Yes, I raised the hand.
Yes,
There are
please come in.
three. There are three hands actually, Chair.
Okay.
It's Litchfield and Honorable Kobe as well. Chair, I think I'm fine with Telana's analysis. I'm learning that in Liberia and Pelican it's 5 composition, and Acacia is 10. And I think the reason Acacia is 10 on residences it's because it's the biggest village, unlike Liberia and Pelican, which are small, Chair. So I would suggest, because the current act speaks of 3 voting members, and the current form of residencies, it speaks of all of them. In Acacia, it's 10, they are voting. In Pelican and Liberia are 5 each, all of them are voting. And with an inclusion of non-voting, which would be officials and subs and so forth, as mentioned, I would suggest, Chair, that the current status or composition, if we agree that it's 5 per village, we can go that, or we can keep the same status of 10 in Acacia, 5 in Liberia and Pelican, so that they also are part of the act. If we with the 8th Parliament, when it comes into effect, or the act when it comes into effect, and new resident committees needs to be elected, at least they know that in Acacia there must be a chair, deputy, the secretary, the deputy secretary, the treasurer, if there isn't, there is, and all those additional members, including the same as other villages, so that they are guided. At least in this, we must be intentional with this act, and it must be able to also touch on areas that were silent, or there were loopholes in the current act that is governing, which didn't stipulate. And these are some of the issues that DPW were managed to maneuver on, because they're not written. So any loopholes that we've identified, and the composition of residence committees is that loophole, it needs to be indicated in this current act. We should be intentional in our approach on how we want to make changes in this current form. Thanks, Chair.
Honorable Litchfield and then Honorable Cobb.
Chair, thank you. Honorable Homotso, I don't want to mispronounce your surname. Why don't we want re-election of members? I'm just trying to understand. Why are we fighting to say the ones that are there should stay? They will be continuity. We are passing a new law based on an old structure. I don't know. Maybe there's something that I'm missing in this. Maybe we'll assist, and maybe Telan will also assist. We are passing a new law on an old structure, and we are saying the old structure must continue as is, and unless there's something I'm missing. It's just a clarity. Thank you.
Chair, I don't think that clarity entirely means me. I think it goes to the meeting, but these are my views, Chair, and I'm not fighting with them. I'm just putting them clear.
Okay, sure. Honorable Kobe.
Thank you very much, Chair. Chair, I'd like to just take maybe Talana back to my initial question to say, what are the material differences between the old structure and the new one? Because if the issue is the numbers, if the numbers of the old look like the composition of the new, then Chair, it will be easier to transpose these the old residential bodies into the new act, because it will materially just be an issue of numbers, and then you can locate who the voting members are and the non-voting members are, and then we can substantially, in terms of substance, keep those members there, if that is the issue. So for me, I just want to know what the material differences are, and once we establish what the material differences are, then we can see how then to align. If we don't then go into, the suggestion of Honorable Litchfield. But because the desire is to keep the composition the same, what are the material differences? And then maybe let's work back from there. I think Talana missed my earlier point because I do understand that the board is going to change, or it will have a certain composition. But my issue is the way residence committees right now are constituted. If the new law, why don't we just, for the sake of keeping the numbers, the governance structures the same, how do we then align with the same numbers or the same composition? Thanks, Chair.
Thank you. Is there further hands, colleagues? Colleagues, are we fine? Telan, can you, yeah, please, we're waiting for you.
Sure. Thank you, Honourable Chair. I did see Annika Clark's hand up, and I think it is important that we hear from her as she did the policy research on the bill. And to respond to Honourable Kobe, as I explained earlier, there is currently nothing governing the composition of the Residence Committee in terms of legislation. And what I'm hearing from Honourable Ramolobeng is that there is different compositions. My concern is that we have to have a sessional official or support staff member and 3 members and the chairperson from the Residence Committee go onto the board. And my concern is that we would not have the same composition currently with these residential committees, because as was explained, the composition looks very different from each village. Can I hand over to Annika Clark? But before I do that, Chairperson, I see 2 ways of approaching this. We can suspend the advert, go back, do some research, do some redrafting, or we can advertise the bill as is with those changes regarding the police, and then know that when we do advertise the bill, we can come back to this section and rework it, should there be a desire of the committee. Because what I'm also receiving from Honourable Litchfield Chabalala is that a question regarding why do we not want a new residence committee to be constituted. But then also I'm hearing from Honourable Ngubani and Honourable Ramolobeng that we should have a continuity. So perhaps this, because we cannot get consensus on this section, we should advertise as is and then know that we will come back when a debate sparks, when we go clause by clause, or we suspend the advert and myself and my colleague Dakshan Kassan go back and consider it. But let's hear from Annika Clark through you, Chairperson.
Thank you, Honourable Chairperson. Is my screen visible?
Yes, yeah, we can see you. We don't know if you are trying to share a document maybe, but we can see you and we can hear you.
Oh, but can members see the document?
No.
Okay,
No, we don't see the document. Yeah, we see it now.
Okay. So to the question of what is substantially different, we've heard now that the composition of the old residence committee is 5 for Pelican Park, 10 for Acacia Park. 9 would be the composition in the new act. The governance arrangements and as well as the function is completely absent for the old residence committee. For the new residence committee, we have detailed the governance and the function of the committee. So what we don't know at the moment is what is the membership of those 5, right? Because Members will recall during our previous committee meeting, there was strong input from the members that we do not want inconsistencies in how the residence committee is composed and how residence committees are functioning, right? So at the moment, we don't know who serves on the residence committees for in the existing villages, and in the absence of an act, we cannot even tell the old residence committees this is how we should be operating. So I don't know if members want to share now who sits on the residence committees of the existing villages so that we can do a comparison, or like Delana said, we advertise the bill in its current format and then allow further consideration in terms of how we would want. Okay, so member Ramulo Benga has now said all 10 members in Acacia Park is members of parliament. So we do not have any representation then from officials appointed by DPWI, as the case may be, or service providers. Yeah, members, my concern is we're going to leave an existing framework in place where there will be inconsistencies in how the residence committees will be operating. Thank you, Chair.
Colleagues, my suggestion is that let's rather advertise and share the kind of information that you need so that we don't further delay the bill. And I think the point has been made by members, but let's proceed with the current bill and then fit into the information that is required so that a final decision is made before a final decision is made on the bill. If we are fine, colleagues, are we at that point where we... Or there's someone who still needs to come in? Please come in.
Yes, Chair, and my hand wasn't up, sorry. No, I think what has just been shared by Honorable Clark make me go back and ask the question. If the governance and the functions were not elaborate in the current committees, why? I don't know, is this maybe linked to monetary compensation? Is it something we are not being told? Because if it is linked to it, maybe I'll understand why we don't want to have told people that they will be compensated monetarily for the duration of the 7th Parliament, and then suddenly we are cutting that short. I mean, it's always not nice to cut short people's monetary compensations. I am one who does not favor that, because I say if it applied to me, I would be unhappy. But apart from that, I then do not understand why we do not want a new election of these parliamentary committees if we are passing a new bill. Just from what Honorable Clark said, honestly, it makes me ask, why are we married? Why are we saying the old ones should continue? And I hear the point about continuity, colleagues. Everything here, we are starting afresh. We could say the same argument by saying we can't take the functions away from the PWP because of continuity. It can only start in the next parliament. No, people, everything new has a certain point where it starts and it will function. So yeah, I'm not happy that we say let's leave it as it is, advertise, and then we'll get the inputs at the time. We are looking at this now, and my sanity tells me we are not making a right decision here. Thank you, Chairperson.
Thank you. As far as I know, because I chair one of the resident committees, no one is remunerated. We just had lots of programs on trying to bring about improvements, and there has never been a clarity in the first place. I think that's what we're emphasizing here, which is why if you look at the 6th Parliament, the committees were elected only once and they served the entire period, but it's not written anyway. And I think the point that comrades are raising, honorable members are raising, is that there has been that vacuum, and people have been doing work to try and bring about improvement. So there was a feeling, but if there is a contrary view, there will be no problem. We'll subject everything to a democratic process. But we don't have to raise suspicions because there is nothing untoward, except that there was that emphasis that when elections happen, people were not told, or in the meeting it was never explained. And then all of a sudden, DPW came back and said, no, the term is over. We were not elected. It sounded as if they are irritated with something. So that's why there was a bit of resistance. But I don't want us to be conclusive on the issue. Let's allow this process to proceed with the bill in its current form. And then if there's any other issue that we want to pick up, we'll do so, including whether we're changing or not changing, because there is a point that is being raised by comrades, by honorable members here. So let's. So where are we now? Do we need to recommend the bill in its entirety, or because we are done with sections, we can just move to close the meeting?
Chair.
Yes, Honorable Rumbleman.
Thanks, Chair. I had raised my hand. I think I'm fine with Telana's second option that she mentioned. I think Anek as well would have raised on that. And I think what Anek would have shared on the composition, the current one being 10, and then the new suggested one would be 9, which is what Honorable Kobe has been trying to seek clarity on, to argue her points on. Makes sense. There is no huge differences in structural changes in that, but let it be. I think I would go with option 2 of Telana to say, let's publish the current act as it is, whilst they are working on how they filter the new suggested amendments, especially with regards to the residence committee, as alluded by members or suggesting in this platform. And then as and when we go, when that time comes for us to agree and effect on some of this composition, we take that decision to it. Like she indicated when she started, the process is not yet concluded. We still are on a space where eventually we'll agree on the act when time comes, so that when we do agree, when that particular time arises, much work would have been filtered in on this, as you have indicated, Chair, when then we have to take a decision, a democratic one, who are informed also on the background work that they would have done. So fully in agreement with that second option, Chair. Thank you.
Thank you, colleagues. We have found each other. Technical team, can you guide me on the next step from here?
Yes, thank you, Chairperson. The next step would just be to a brief summary of the public participation way forward. Can I continue, Chair?
Yes, proceed.
Okay. So what we need now, Chairperson, is an instruction from the committee that we may proceed with the bill as amended today for publication, for public participation input, which we have received now, Chair. So the NA rules requires the committee to publish the draft bill in the Government Gazette for at least 3 weeks. And it also requires the committee to report to the National Assembly when that bill has been published. So for the ad hoc committee process, now that we have the bill that will be amended, it will be published in the Government Gazette of Friday, 17th of February, with a closing date of 7 August 2026 for receiving written comments. So that will be a 3-week period. The committee will then, upon publication in the Government Gazette, the committee does need to convene a meeting just to adopt its report, because the NA rules requires us to report to the National Assembly when adopting that, when publishing the bill. We have a proposal for next week, Friday. It will just be a 30 minutes, Honourable Chair and members, to adopt the committee report to the National Assembly. The bill will also be placed, the recommendation is also for the bill to be advertised in national newspaper publications. So we look at the object of the bill to determine what is reasonable public participation to be followed. So we do recommend at the minimum that it be advertised in national newspapers. So for both the Gazette and an advertisement, we're asking for persons to give written input, but also asking persons to indicate if they would like to make an oral submission and address the committee again. Publication on the 17th of July, closing date of 7th August. There is a question, does the committee want advertisements to be placed in community newspapers as well? So those are your local newspapers, which could then also be advertised in the different official languages. But again, we do need to have consideration of the object of the bill. So I'm not saying the bill does not affect the broader public, because it is still the use of government funds. So a committee decision is just necessary on, can we just stick to the national newspapers, or does the committee want community newspapers as well? Then the bill will also, the advertisement calling for written inputs will also be translated into all official languages and placed on the Parliament website. Again, allowing for a 3-week period for receiving written comments. Correspondence will also be directed to identified stakeholders. Members, in summary, this is everyone that attended our workshop on the 24th of April. In addition, we've also asked DPWI for the details of all service providers that are currently in contracts with DPWI. We've also asked DPWI for the names of all persons employed by the department in posts relating to the parliamentary villages. Members will recall that there's transitional provisions related to service providers and staff members. So these list of stakeholders will also be will receive correspondence calling for written submissions and asking if they would like to address the committee. So in short, Chairperson, that's the proposed public participation way forward, and just requesting input on the members. Can we stick with the national newspapers, or should we consider community newspapers as well? Thank you, Chair. Sorry for rushing through.
No problem. Members, here the suggestion. So if, because Parliament is technically on recess, can you just explain to me how we're going to report back to Parliament on the Friday, the 17th? Because I don't know. Are you going to be able to assist us to ATC the report for consideration, or what's going to be the process? And then members, if you can just come through with regard to the newspapers, my suggestion will be we use 2 or 3 national newspapers based on, also take into account, there's some provincial national papers that exist that we can utilize so that we can at least cover at least the greater part of South Africa. Over to you, members, just on the procedural issues.
Yes, thank you, Chair. You're absolutely correct. So if the committee agrees on meeting next week, Friday, we adopt the committee report. The ATC will still be published. So we'll adopt the report next week, Friday. It will be sent to ATC. And when the NA then reconvenes, Chair, they will place it on the order paper as per the agreement by the programming authorities in NA. Thank you, Chair.
Thank you, members. Are you fine with everything else so that we can adopt this procedural issue and then we conclude?
Yeah, Chair, we are fine. I think I want to support you on the issue of national newspapers, but also let's just be sensitive so that we cover areas of our people. So let us look at maybe other papers which could be provincial, just so that we know we've covered all sectors where our people are. But yeah, I agree, Chair, with the proposed way forward.
Thank you. Colleagues, can I then get a mover and seconder? Because we've done so for the bill on the procedural issues that have just been outlined now. To allow the team to... Thank you very much.
For the adoption, Chair.
Thank you. Thank you, Dr. Litchfield. Thank you very much. The procedural issues have been seconded. Are there any other outstanding issues?
Not from our side, no, Chair. Ms. Alistaki?
We are good, Chair. Thank you.
Okay, perfect. So we are done. Thank you, colleague. I know it's always not easy to convene these meetings, but we have an obligation to ensure that we can conclude this process on behalf of Parliament. And I thank all of you for the cooperation, our technical team, honorable members, and everyone who has supported this process. I'm quite impressed that we've been able to reach where we are. We've tried to the best of our ability to cover different areas. Thanks to the technical team, thanks to the MPs, we will then get a notification on the next step and the next meeting. The meeting is officially adjourned.